An Accra High Court has granted expedited hearing in the case seeking to compel President Akufo-Addo to accept the anti-LGBTQ plus bill for possible assent. South Dayi MP Rockson-Nelson Dafeamekpor maintains the case has important constitutional considerations and must receive urgent attention. My colleague Joseph Ackah-Blay is joining us via phone with details in relation to this, and this trajectory has been on for quite a while in relation to quite a number of things as to the case going to the Supreme Court in relation to Rockson-Nelson Dafeamekpor and the injunction which was put on the president's ministerial nominees and the back and forth that's been associated with it. Let's connect with my colleague Joseph Ackah-Blay right now for details. Joseph, first, was this request opposed by the attorney?
No, Marina. Representatives for the Attorney General President Court did not request. You recall that in the previous matter that you had alluded to, the case that came up at the Supreme Court, you recall in that particular one, the Attorney General's office had explained that they have actually made a request for such an expedited hearing. And the issue had been raised that whether for such a situation as this particular matter, whether it was something that the AG was minded to make such a similar request. We know that the AG's office said no, but when the case was called, the court was informed that they are not opposed to the request for an expedited hearing by lawyers for the South Dayi MP. And so that request was therefore granted by the court because of the fact that there was no opposition to it, and the court also felt it was only fair that such an expedited hearing.
And what transpired after that request was granted? Because we know that they were pushing for April 4, that is well past and gone. What happened afterwards?
Once the request was granted, the court then called upon the lawyer to move the motion. And so this is an application asking the court to compel, first, the Speaker of Parliament to transmit the bill, then secondly, for the presidency to accept the bill, and for the presidency to indicate within 7 days whether it will assent to the bill or not. The legal argument in support of this position was to the effect that as far as the lawyers for the MP are concerned, the laws are very clear that the president simply has no say and he cannot tell Parliament not to do its work of transmitting the bill. And so once Parliament had duly passed any such law, he cannot hide behind any supposed pending case to decide that because of that fact, he's not going to allow Parliament to even simply present the bill to him. And so that was the argument they advanced to make the point that they believe that the limits that they ought to meet to demonstrate to the court that the president was under a legal duty, which he has failed to perform and should be compelled from that legal duty. That threshold has been met. Lawyers for the Attorney General at that point indicated that they had some legal points that they have to raise, and so they would need some time to file those legal arguments. And so the court adjourned proceedings to the 18th of April to allow for the Attorney General's lawyers to file the legal arguments in response to the arguments that have been advanced by lawyers for the South Dayi MP, Marina.
Right, and Joseph, we're going to stay with you on the courts because we know that still at the High Court, the court has struck out a suit by the Democracy Hub and some